Good afternoon and welcome to episode number 44 of At Your Service with Haber and Martinez, entitled Judges Are People Too, a Layman's Guide to the Judiciary with the Honorable Lody Jean. That's correct. Ed and I are going to be joined with a special guest, Lody Jean, who we will introduce you to at about the halfway point of our show. Judge Jean, who is a sitting circuit court judge, is up for re-election. And we're very happy and proud to have her come on and talk to y'all a little bit about who she is and why she thinks, and we agree, that she will continue to make an excellent judge here in Dade County. But before Judge Jean comes on, Ed and I are going to talk to you a little bit about my favorite subject, well, one of my favorite subjects, and that's history. We're going to talk a little bit about the judiciary. If you read my promo today, then you understand etymology of the judicial system, the nature and the role of courts and judges, federal versus state. We want to give you a little bit of a background because, as is the case with voting, and we'll talk about this a little bit more, many people who are non-lawyers, we'll just call them laypersons, I don't want to use the word ignorant, but they're just not informed or educated when it comes to matters of the judiciary. They don't live it every day. It's not part of their lives. And they don't really teach it today in school, at least not the way they used to when we were kids. And so out of sight, out of mind, most people don't understand the dynamics of how one becomes a judge, what makes a good judge, what makes a bad judge, and why it's important that people understand who's on the bench and how to either keep them there or get rid of them when they shouldn't be there. Anything you want to add to that before I get into our history lesson, Ed?
No, my friend. This is your opening monologue. I got plenty to say, so let me I'll jump in when I'm ready.
Okay.
Start with the history lesson.
Let's go through a little bit of history. So everybody understands that the United States became its own sentient country as a result of basically immigrants from Europe, England in particular, that ultimately became fed up of being ruled by a monarch. And we wanted our own system of government. And ultimately, in 1776, we became the United States of America. But our system, even then, was in large part based upon the English system. While we changed things up, we no longer went by a monarchy and a king. We instead came up with a three-tiered or three co-equal branch system of a democratic republic as opposed to a monarchy. But still, much of what we do and much of how it's done is premised upon that English system. And that's especially true when it comes to the issue of the law. Here in the United States, the law is premised upon British common law. And where did that begin? Well, that began back around the year 1066 when England was formed. I don't know if any of you saw the TV series Vikings on the History Channel. It's a great show. It's a fun show, especially if you can handle the blood and gore. But it's also in part based on fact, because it was the British Crown, that 5 separate British crowns that were all being attacked by North people, Scandinavians, who were raiding, and ultimately all of them united, that is the 5 kings of England, to one crown, and became a nation. It became Britain. And so the king's courts were what ruled at that time, and basically the king's courts were whatever it was that the king decided, that was the law. And he did marshal off some of this authority to what we could call maybe underlings, right? Lords, were people who were major landowners, things like that. They were able to do some local responsibility in terms of making legal decisions when there were disputes between people for whatever reason or another. But it was still archaic. Remember, we're talking about the 10th century and the 11th century here. So at that time, the number one way that people had trials was what was called a trial by ordeal. Ed, do you know what a trial by ordeal is?
No, that I do not know.
So a trial by ordeal...
Well, I can tell you that even today, a trial is an ordeal.
That's true, but it's a different type of ordeal, because a trial by ordeal meant that you had to suffer through some significant act in order to either be proven innocent or guilty. So, for example, one of the things that they would do is they would take an iron rod and set it in a pit of flame until it was red hot, all but molten. And the accused would then have to pick up that iron rod and hold it. And if that person healed they were innocent. And if that person didn't, they were obviously guilty. So that's an example. But I have another example, and we're going to show it for you. And I apologize, it's going to take a moment or two, but I hope that it's worth your time. If our producer would cue up the video, this is an excellent example of a trial by ordeal. Go ahead.
We have found the witch. May we burn her?
How do you know she is a witch?
She looks like one.
Bring her forward.
I'm not a witch. I'm not a witch.
But you are dressed as one.
They dressed me up like this.
And
And this isn't my nose. It's a false one.
Well,
well, we did do the nose
the nose?
and the hat, but she's a witch.
Did you dress her up like this?
No.
No.
Yes. Yeah, a bit. She has got a wart.
What makes you think she is a witch?
Well, she turned me into a newt.
A newt?
We got better. Burn her anyway!
Quiet! There are ways of telling whether she is a witch.
Are there? Oh, what are they telling us?
Tell me, what do you do with witches? And what do you burn apart from witches?
Poor witches!
Wood. So, why do witches burn?
Because they're made of wood.
Good. So, how do we tell whether she is made of wood?
Build a bridge out of her.
Ah, but can you not also make bridges out of stone?
Oh, yeah.
Cool.
Does a wood sink in water?
No.
No, it floats.
It floats. Throw her into the pond.
What also floats in water?
Bread. Apples. Very small rocks. Cider. A great gravy. Cherries. Mud. Churches. Lead. A duck.
Exactly. So, logically,
If she weighs the same as a duck, she's made of wood.
and therefore,
A witch! A witch!
very good. We shall use my larger scales. Right. Remove the supports.
It's a fair cop.
What did you see?
Okay. Thank you very much. So, thanks to Monty Python and the Holy Grail, that's an example of trial by ordeal. These are ways that medieval folk tried to resolve issues, right? Fortunately, King William II in the late 11th century banned trial by ordeal. However, there was a substitute which was not any better in terms of its ability to accurately determine guilt versus innocence, but it was determined to be better than actually trial by ordeal, and that was trial by combat. So what they would say is, if you were accused of X, rather than being judged by the king or the king's emissary, you could decide to have somebody fight, and if that person fought the king's choice to fight your choice, whoever won ultimately was the victor. Any of you who may be Game of Thrones fans, I'm going to throw that out there as a third entertainment type reference. You may recall that the trial by combat was used at least twice during the course of that show. Once when Tyrion Lannister was at the Eyrie and he had Sir Braun stand in and fight for him. And instead of being judged and found guilty of treason or whatever it was that they were trying to accuse him of, Sir Braun won, and therefore he was acquitted. It was subsequently done with Cersei when the freaky guys from the ministry the Sparrows wanted to try her, and Cersei insisted on trial by combat, but her son, King Tommen, I believe, said no, and he eliminated the trial by combat ruling wisely, and as was historically accurately done, that it's got no bearing on guilt versus innocence.
You lost me at Game of Thrones.
he or she who has the better knight or fighter or stronger or better warrior does not necessarily mean that that person is innocent or guilty. Anyhow, we fast forward to the 12th century when the Court of Common Pleas was created. The Court of Common Pleas was basically a jury trial. It was presided over by 12 knights who sat in judgment. We fast forward to the 1300s, and now you've got all of these problems with all of these judges, alleged judges in England at the time, who were now subject to all sorts of other stuff, like trying to rule in a way that they thought would curry them favor with the king, or accepting bribes, or all sorts of other stuff. So at that point, the king ultimately started a affirmation process by which judges had to affirm that they would be loyal to nothing other than truth and honesty, and that they would not accept bribes or rule simply in the name of the king. Common law courts became courts of chancery. So in these times, we had what was called a Lord Chancellor, who was a person appointed by the king and was actually referred to as, quote, the king's conscience. And so this person was now really like a true judge who was sitting in judgment as the king instead of the king himself. This is where courts of equity came from. This is where the concepts of fairness came in. Because prior to this court's conscience and courts of chancery, what was done was done. But here, people actually had the ability to say, the court made a ruling, or the knights made a ruling, or the king made a ruling, and I don't agree with it, and I want it reviewed. And that's really the basis of two things: appellate courts, which review judgments or rulings or decisions by trial courts, and also, again, the concept of equity or fairness being important to the legal process. Because sometimes the black letter of the law, the black or white letter of the law, leaves no gray area. And gray area, obviously, as we all know, is important.
That's where we live,
now,
really.
So
where
now
we live as human beings.
Let's fast forward to the United States. So in 1776, the Declaration of Independence is signed. We become a country, and the Constitution gets ratified on September 17th of 1787. Article 3 creates the Supreme Courts and, quote, such inferior courts as the Congress may from time to time ordain and establish. We created courts of law and equity in this country. That was a guarantee by our founding fathers. In August of 1789, not August, but in 1789, George Washington would also sign, quote, an act to establish the judicial courts of the United States. So, what do we have in the United States today? Pursuant to the federal system, we have the Supreme Court of the United States, which is the final word, the final arbiter, the final say on the law of the land. Now, that said, as we all know, as has recently happened with Roe versus Wade and other types of decisions, the Supreme Court is always free to review its own rulings. But at the end of the day, it is the Supreme Court that has the final say,
Well, listen,
even if it...
I would go further than not just it's always free to review its own rulings. I would say it's actually part of their job. It is one of the main tenets of especially an appellate court is to constantly have people have the opportunity to address their rulings because of what you said earlier that I chimed in. We live in a gray area. As much as the legislature many times wants to make everything black and white, life is not black and white. And so that's why the appellate courts, it's important, especially I think in this country, for people to understand that they need to be free and independent from everything, because what every fact pattern is different. Even a tiny little change in the fact pattern could alter the outcome of the decision of the courts. or the judge of fact. What we call for you guys that aren't lawyers, we call them the trier of fact. And why is that? Because sometimes you're a jury of our fair and impartial. I almost said our peers. My pet peeve. A fair and impartial jury of people. But sometimes it could be the court, either in a bench trial or an appellate judge who's sitting in an appellate capacity. So let's try to refer to it as a trier of fact, right? Trier of facts have to try the facts, and every little fact changes potentially what the outcome of that case is going to be. And so courts not only have the right to do it, not only should they do it, that's really what their job is. Nothing is ever set in stone, like Roe v. Wade.
So that said, again, the United States Supreme Court is the final arbiter. That is the number one top tier, end of the line court in the United States. Underneath the Supreme Court, we have circuit courts of appeal. There are 13 of them throughout the country. And then under those 13 circuit courts of appeal, we have 94 separate district courts of appeal. That is the federal court system. All federal judges are appointed. They are appointed by the executive branch, meaning by the president. They are approved by the legislative branch, meaning the Congress. And then they have lifetime terms. They cannot be removed, except they can be impeached if they do something illegal or unethical, and they get called in front of Congress to answer for it.
But a bad ruling is not an impeachment. An incorrect ruling.
And we'll do a different show on impeachment. But the bottom line is, I want you guys to understand that the federal judicial system is a purely 150% entirely political process. You have to be appointed by the president. How do you get appointed by the president? President's got to know who the hell you are, or somebody close enough to the president who has the president's ear has to know who you are. How does that happen? Politics. Then you got to get through Congress. How do you get through Congress? Politics. How do you get a bunch of senators to say yay? Politics. It is a purely political process. And once you are in, you are there for life. Again, it's like a life term, except the one possibility for impeachment. Now, that's the federal system. As we all know, the Constitution also says in Article 10 that all powers not reserved to the federal government are reserved for this, all not given to the federal government are reserved for the states. So the states, each of the 50 states, have their own judicial system independent of the feds. And the systems vary from state to state. In fact, Ed and I are going to do an episode of AYS where I have a criminal defense attorney from California who's going to come on and join us. And we're going to dedicate that show to talking about some of the fundamental differences between state law from state to state, specifically in that case, California to Florida. But honing in on Florida, which is the only state that I'm licensed in, so I'm not going to speak about any other. Here in Florida, judges can be appointed if there is a vacancy, but otherwise they must be elected, which again is a political process. However, judges do not run on political lines as they are supposed to be nonpartisan. It's supposed to be irrelevant whether a judge is a Democrat, a Republican, an independent, a libertarian, a communist, a socialist, or whatever the hell they may want to believe in or register as. That is not to have any bearing on their ability or electability as a judge. So you can be appointed in the event of a vacancy. We'll talk a little bit about that later, or you can be elected. In Florida, we have a similar structure to that of the federal government, in that the highest court in the state of Florida is the Florida Supreme Court. So as to state court issues, the Florida Supreme Court, just like the United States Supreme Court is for federal issues, the Florida Supreme Court is the final arbiter of law and fact here in the state of Florida. Underneath the Supreme Court of Florida, we have 5 district courts of appeal. Notice the language is a little different between the feds and Florida. And we have 20 circuit or trial courts, and then we have 67 county courts. Let me talk about Miami-Dade County for 1 second. First of all, Miami-Dade County is clearly the largest judicial circuit here in the state of Florida, but we also are the 4th largest judicial circuit in the entire nation, state-wise, not federal. Right. So it's pretty big. We have 123 judges here in Miami-Dade County. 43 of them sit on the county court. 80 of them sit on circuit court.
Before you go, remember, sure. County court is misdemeanors. Circuit court is all felonies. So
For criminal purposes, but in civil,
For
there are
criminal
other
purposes,
there are
correct.
other issues.
for civil purposes, it boils down, generally speaking, to the amount of money that's involved in the law.
Small claims.
A couple of other factors, but generally speaking,
Well,
and
you
family
have things
courts are
like
circuit.
landlord-tenant matters are generally held in county court civil.
And
Um,
family matters are circuit.
So we have 4 main courthouses here in Miami-Dade County. We have several satellite courthouses, but the 4 big courthouses that we have here are the main courthouse is the Miami-Dade County Courthouse. That's the one at 73 West Flagler Street. And that does circuit and county court civil and probate matters, period. Nothing else happens in that building in a courtroom. Plenty happens in that building, including
Right.
asbestos poisoning. But as far as law stuff goes, it's circuit and county, civil and probate. Next, we have almost across the street from it, we have the Lawson E. Thomas Courthouse, and that's for circuit and county court family and domestic violence cases, but it also handles misdemeanor domestic violence criminal cases, only misdemeanors.
Only Mr.
Then we have the Richard E. Gerstein Metro Justice Building. That's over by the Jackson Complex. That's the main criminal courthouse, which handles circuit and county criminal court cases, except it does not handle any county court misdemeanor domestic violence cases, because those are over at Lawson Thomas. And then finally, we have our newest courthouse, which is the Miami-Dade Children's Courthouse, which handles circuit and county court juvenile delinquency and dependency matters. So, how do we deal with our judges here in Miami? As I said, judges are elected, okay? And in order to be elected a judge, all you need is more people than not to vote for you, meaning more people have to vote for you than any of your opponents, okay? And the only criterion, there's only 3 criterion to be a judge here in the state of Florida, which would include Miami-Dade County. And that is 1, you have to have a law degree. So you have to go through law school. That was not always the case, but it is now. 2, you have to be a member of the Florida Bar, and it's kind of 2A, 2B. 2A, you have to be a member. 2B, you have to be in good standing, meaning you can't be suspended, you can't be subject to discipline, you have to be on the up and up. And then finally, number 3, you have to have been a lawyer for 5 years. That's it. Those are the only 3 requirements to become a judge.
And
if you can get elected, if
you know I'm not saying who, some of these retired judges, borderline breathing, like that's a gray area as well.
Well, my point to the folks is that, and it's what we're going to talk about when Judge Jean comes on, because she's a wonderful example of a judge that hits all marks, right? So Judge Jean, I guess jumping the gun a little bit, Judge Jean was first appointed as a judge. She was a private lawyer working in her private capacity, doing criminal defense work and immigration work. She had been doing that for, I don't know, maybe 6-8 years, because she had just left the state attorney's office after spending 8 years as an assistant state attorney. So she was assistant state attorney who then went into private criminal defense practice and immigration practice. And at that time, Governor Rick Scott pulled her name out of the bag and said, I think you'll make a wonderful county court judge. And he appointed Judge Jean to serve as a county court judge, where she sat in branch court, I believe. I think she was first seated at North Dade, maybe. I could be wrong on that. But either way, it was definitely county court. And she was hearing either misdemeanor cases or those types of matters. And then if you fast forward 2 years from that, that was, by the way, Governor Scott appointed her on November 16th of 18. And then on 4/17 of 20, Judge Jean was bumped up by Governor Ron DeSantis to circuit court. And so now she presides over felony cases at the Richard Gerstein Metro Justice Building. So Judge Jean is a great example of how a judge gets appointed. Her name was nominated. She went through the screening committee of the judicial nominations process. The governor picked her, and then another governor bumped her up to an even higher level. And now she's running to retain her seat, because you could be appointed, but that appointment ends at the end of that term. And the only way that you can stay a judge is if you get reelected. So she is now running, actually elected, because she never got reelected. So she's running for judge now.
Right.
So
I don't want to complicate. I don't want to complicate things too much, but just to be 100% clear, it is the county and circuit court judges that are elected, and like Michael said, you're appointed if there's an opening because they're elected for 6 years. But let's say somebody retires before their term is up. Well, that seat needs to be filled, so you're appointed until that term of the seat. So if you're appointed today, that doesn't mean you have to run 6 years from now. If there's 2 years left in that seat when you're appointed, within 2 years you got to run. If you win that, then you got 6. And appellate judges, meaning the appellate courts or the Supreme Court, are appointed only. Every once in a while, you'll look at the ballot, and what you'll see is for those judges, it'll come up, do we want to retain them? And very few, I don't think I've ever seen a judge that was not retained in the appellate capacity. Have you?
Not that I can think of off the top of my head, but who knows?
That was not retained.
My thing that I want you guys to understand is when it comes to where we are now, and Judge Jean, as I said, is running for election, lawyers tend to be the electoral voice for judges. Why? Because we know them, we work with them, and they impact our careers. This is critical to us who's on the bench. But the truth is, it's even more critical to you. It's more critical to John and Jane Q. Citizen, because you never know when you might wind up in a courtroom, or when one of your loved ones might wind up in a courtroom, or whether your business or corporation or entity that you work for might wind up in a courtroom. Judges are very powerful. They affect people's lives in an uncountable number of ways. And if you don't know who you're putting on the bench, if you're voting for somebody just because you like the way their name resonates in your mind, or because they happen to share your gender or your sexual orientation or your religion, or any of a number of factors that make sense why you might choose somebody over someone else, but what you don't know is, who is this person? What do they stand for? What is their ethics? What is their background? What is their experience? I mean, Ed and I can tell you horror stories about judges that we've been appeared in front of who have been elected, who the people have put a robe on, who are so unbelievably incompetent that they should never be sitting in judgment of anybody else.
Let me jump in there, Mike. Mike, I had a show since 2000, radio show for years and years and years. And at one point for about 3 or 4 years, maybe more, every Tuesday or Wednesday, I did a show about the judicial elections. And when Michael says they are woefully incompetent, it is in the true sense of the word. Let me explain what he's trying to say. And it's crucial. Not everybody is cut out to be a good judge. They could be the most amazing lawyer on the planet. Okay? He could be the greatest lawyer since Clarence Darrow. If you don't know who he is, look him up. But that's spelled Darrow with a W at the end. It doesn't mean they could be a good judge. Let me give you an example. Michael Jordan may have been arguably the greatest basketball player that ever lived. But the question is, would he make a good referee? And what do I mean by that? Is Michael still going to get the juices flowing when he sees a tight game? Is he going to want one team to win over the other? Is he going to be influenced by a guy who's a tremendous player? I'll give you an example, Mike. I played baseball. One of the hardest things for an umpire to do is to see a player make a great play, just an amazing play, but the runner is still safe by just that much. So, for example, hot smash down the line, third baseman makes a diving backhand catch, gets on one knee and fires across the diamond. Oh, my God, it's exciting. But the runner beat it by half a step. A player who's umping is going to feel for that guy and might want to call him out. But a good umpire is like, man, what an amazing play. But sorry, bro, you missed it by that much. And the same thing happens to judges. You get on the bench and you feel like there's an injustice happening because the law is wrong. It's not your job. The prosecutor might not be, it's happened to me. I'll give you an example. It happened to me once where I filed a motion to dismiss. It's an evidentiary hearing, and the prosecutor has to put on evidence. They have to put on witnesses to testify. And the young prosecutor didn't know that. We had the hearing date. Prosecutor said, no, Judge, I don't have any witnesses. I have nothing. I'm resting on my written response. And the judge told her what to do and gave her more time. Now, my client didn't have money for an appeal, but that's an appealable issue because the judge should not get involved. Now, I get it. I'm not going to say who the judge is. I love her. She's wonderful. I understood what she was thinking in her head. But that really was inappropriate. She needed to be like that umpire, looking at a great play and thinking, I wish I didn't have to call this guy safe, but you're wrong, sweetheart. They should have granted my motion. So it's nothing detrimental to say they're woefully incompetent to be judges. It's just some of them are a little too emotional.
What I meant by woefully incompetent is we get judges that are on the bench who have never practiced in a courtroom a day of their lives. They do not know the rules of evidence. We wind up with criminal court judges who have never done criminal in their life. They have no idea what the criminal rules of procedure are. They have no idea what the case law is. That is what I mean by incompetence. And the reason that they're there is twofold. One, because the public was dumb enough. I wouldn't say dumb enough. That's not fair. The public was ignorant enough to vote them in.
They didn't know.
And or the hierarchical structure of the administration of the judges was foolhardy enough to place them in a position where they had no experience, as opposed to putting them somewhere where they actually do have some kind of knowledge and base foundation of knowledge.
And again, it's not saying anything bad to the judge. They were put in a position where they were set up to fail because they didn't know the law.
And
in that area.
So that part of it is not on the judge, where they get assigned. That when you run for judge, you don't run for criminal judge or civil judge or family judge or probate judge or delinquency judge. No, you just run for judge. It's up to the administrative office of the courts, the chief judge and staff to decide, where do we put them? Do we send them off to branch court? Do we put them in one of the main courthouses? Do we put them in civil or criminal or probate or family or juvenile? That's all an internal mechanical thing that the voters have no control over. But what you do have control over is, who do you vote for? And how do you know who to vote for? Well, I can tell you, I've been practicing law for 31 years. I have very good friends and family members who, for 31 years, have been calling me saying, who do I vote for? Tell me who to vote for. That's how
my mother every year. Eddie, what judge? Thank God she started voting. She only started voting for judges, first of all, since I became a lawyer. Because that's the other thing, Michael. Most people don't vote for judges.
That's true.
And it's important.
This is really, if you take nothing else out of this show, what we want you to really know is the judiciary is really important to all of us, and you have to pay as much attention to it as a citizen, as a voter, as you would the president of the United States, the governor of your state, the mayor of your city. All of these things, they're all equally co-important. It's why we have three co-equal branches of government. The executive is no more powerful than the legislative, which is no more powerful than the judicial. That holds true on the federal level, and it holds true on the state level, and it holds true on the local level. And you guys need to get your voice heard, and it's got to be an educated, informed voice.
And before we bring on Judge Jean, I want to point out a few examples of what you can do if you don't know a lawyer, or if you know, let's say, only a handful, one or two. They're not going to know everybody who's running for judge, and they're not going to even know if these people are qualified. Let me give you just a handful of things you can do. Okay, you can get the ballot in advance, and you can see who's got opposition. Because if they don't have opposition, there's no point in even researching them, because they're going to win by default. But look at the ones who have opposition. Number one, you can go to the Florida Bar website. You can look up their name on the Florida Bar website by Find a Lawyer. Okay, and even if they're a judge, they'll be there. And the first thing you want to look at is, how long have they been a lawyer? How long have they been a lawyer? And why do I say that? If they've only been a lawyer for 5 or 6 years, odds are very high that they are not qualified yet to be a judge. Because like everything else in life, you haven't had enough life experience in the legal community as a lawyer to really be a good judge. You've got to be around for a while. Now, if they're a prosecutor or a public defender, they're going to have a leg up. Why? Because 5 years as a prosecutor is probably equivalent to about 10 to 15, maybe even 20 years as a private lawyer, because you have 300 cases, 100 to 300, depending on where you're at, all the time. So you're in trial all the time. You're in a courtroom every single day, which is also crucial, because while I may not have a case when I was a prosecutor, I'm sitting in the courtroom and one of my colleagues has a motion, and I get to hear that motion, and I get to find out about that law, because I'm sitting in the courtroom every freaking day. So you're going to be exposed to a lot more law just because you're in a courtroom every single day. How old are they? Why is that important? May not mean much, but generally speaking, a judge is going to make about 140,000. I think they're up to about 143, give or take, depending on whether they're county or circuit or appellate. $143,000 a year. If you're a good lawyer, you're going to make more than $150,000 a year.
Sorry to
So
interrupt.
if you're 35, 40
Ed,
years old,
Ed, hang on a
why are you
second. I
taking a
think
pay
Judge
cut?
Jean is with us.
Correct.
Are you there, Judge? I can't see your face.
I'm here. Oh, here I am.
There
There
you
she
are.
is.
Hi.
And it's a
Good
beautiful
afternoon.
smile.
Welcome,
so I
Your
want
Honor.
everybody to see that beautiful smile,
Good to
which
see
I
you,
don't get to
Al.
see that often on the bench. Just want you to know.
The what?
We don't get to see that very often on the bench. We need to see it a little more on the bench.
Oh, a little bit more laughter, huh?
And a little bit, just a little bit.
Yeah.
Have a little fun with it.
I mean,
Let
we
me-
are working when we're on the bench and in court, so it's kind of hard to
Yeah.
crack a joke.
Well,
Let
you
me
have to crack a joke,
introduce
but a little smile every once in a while.
Ed, let me introduce the judge to the folks. We were talking before you got on, Your Honor, about how judges become judges, appointments, elections, et cetera, et cetera. And one of the things that I really wanted to get across to the people was what we want as lawyers and what citizens should want is intelligent, experienced, patient, courteous, humble, compassionate, punctual, open-minded, courageous, fair judges who use common sense. And you are the prime example of just such a judge. And we're thrilled to have you on board because we want the folks to know who you are. We want them to meet you. We want them to learn a little bit about you. And they don't get to experience you as we do, observing your courtroom demeanor and how you treat the public, the respect that you show people from the bench. But you epitomize what we want. So
And-
thank you for being there, and thank you for
Let
being
me-
here.
Let me segue into the last thing I said. For example, Judge Jean, you were at the state attorney's office for how long?
I was there for 8 years, and at the state attorney's office, we were basically in courts every day, trial active, litigation active. And I'll just say two things. I had great mentors and role models as a young professional. I try to emulate that, right? And secondly, I know we'll get into that also. I'm Haitian American, born and raised in Haiti, and my immigrant background, like so many others that live in Miami-Dade County, is at the forefront of my mind when I serve. Because I get to participate in a judiciary, right, in a justice system that so many of us don't have back home. So service, fairness, access to the courts is always something that's on my mind as I go into work.
Right. And so, like what I was saying earlier, see, when Judge Jean is at the state attorney's office for 8 years, I mean, I don't think there's anybody who could give you a quantifiable scientific number, but that's got to be equivalent to about 15 years or 20 years of legal practice because of what she just said. And I said earlier, when you're a state attorney, you're in the courtroom every single day. Even if you go to a special unit, which is, something that I'll explain in another show, you may not be in court every single day when you're in a special unit, but you are immersed in the legal world and that courtroom, even if you're back in the office every day, because when you're in a special unit, I don't know if you were Judge Jean in a special unit, were you?
I wasn't. So I was always in court.
Oh,
And so
you were there every day.
yeah.
But she was,
Every
Judge,
day.
if I'm correct, you were a division, you left the state as a division chief, correct?
Right. So, my old boss, Kathy Fernandez Rundle, always asks for a three-year commitment. I was there 8 years. 4 of those 8 years, I was supervising a courtroom. So I was there just about every day. If I wasn't there every day, I was there four days a week. And, they called us pit prosecutors or line prosecutors. I mean, we were there just dealing with a daily caseload. And the way that criminal arrests work, you have to have court open every day. Bond court is open 7 days a week, but regular courts every single day.
Right. And a person like Judge Jean, who's been there forever, was a chief. So she worked with people that she had that were underneath her. She was responsible for teaching, right? Because that's one of the things a division chief does. She'll have the young prosecutor, which is the youngest in the division, which is a C prosecutor. And that job basically is like training a puppy. I don't mean that in a bad way to any C prosecutors. We were all there. I was there. Judge Jean was there. We're like wide-eyed puppies. We were ready. We're in felonies or big cases, and this is what we want to do.
And
you need somebody who can train you.
A couple months out of law school, they were throwing us in to handle evidentiary hearings or trials. I mean, I had my colleagues that went to like these big named law schools they envied me because they were busy writing memos to the senior partners where I was in courts litigating. So it was
Right.
funny to see. I remember having a very good friend of mine. Her name was Karen. She went to Yale undergrad, Harvard Law School, and she envied me and my,
I'll
and my
bet you envied her paycheck though.
right. That was something different, right?
That's
So yeah,
all.
she didn't envy my paycheck, but she envied everything else.
I'm sure because
So
and there's even some lawyers who go out of law school private and have come to the state attorney's office because they realized once they were private they just couldn't get the trial and the courtroom experience, and they've come to get some trial and courtroom experience. Some
Yeah.
have stayed because they love it because it really is a great job, and
I
some
mean,
have
I think
decided
it's
after they got the experience to go back in the private.
I
I
think one
tried
of
my first, not to cut you off, Mike. I'm
Go
sorry.
ahead.
I
No,
tried
no,
my
please.
first, yeah, my first jury trial. I was 6 months a lawyer. 6 months a lawyer. No private law firm is going to let some 25-year-old, fresh out of law school student try a case, right?
Well,
But we did. We had to.
Yeah,
one of the very nice things about having you on the criminal bench is your significant experience in criminal law. Unfortunately, some of your colleagues don't have that experience. They're sitting on the criminal bench and they never, I mean, apart from maybe taking criminal law and criminal procedure in law school 100 years ago, they have no idea. Whereas when we walk into your courtroom as lawyers, as criminal defense attorneys, you know, we know one thing's for certain. You know the law. You know the procedure. We may or may not like the ruling that we ultimately get. That's not the issue. We're getting a fair shot by somebody who really understands the
Right.
game.
And
That's go ahead.
I can tell you this. It is an adversarial system, right? People want to be heard. People want someone to be professional, respectful, take the law, apply it to the facts. And I found that most folks respect the final conclusion if they believe the process was fair, right? And so that's what I strive to do every day. Just give everyone that appears in front of me a fair process
Right.
because, it does help to know what the subject matter is, right? But I'll tell you this, I was in county court civil before I was in circuit criminal. And that was a brand new world to me. Same set of skills that I applied. I got great feedback from the county civil lawyers. And they had no idea that civil was not my background.
I got to tell
So
you,
you were
I may
doing
be
like
biased.
PIP cases and small claims matters and landlord tenant issues.
Yes.
And
Listen, I may be biased. I'm sure I am, but I can tell you, having been in the belly of the beast, if Michael, you've had a lot of judges, and that doesn't mean other judges aren't up to par, but as a whole, former prosecutors thrown into another area of the law tend to get up to speed faster, and this is why I think it happens. Not because we're smarter or because we're better. It's because we have that training. Judge Gene will tell you, you get thrown into the wolves as a young prosecutor, not knowing a thing.
Well, I think you can make the
You
same.
know nothing.
I think you can make the same argument for former public defenders as
Public defenders too.
Absolutely. Absolutely.
We
But
get
what
thrown
we
into
find-
it, and we've got
what we
40,
find-
50, 60 cases, all different charges, different laws that apply. If you get, a good prosecutor or a good defense attorney on one side or the other filing motions, and you got to get up to speed, and you've got to be able to research and read fast. And I think that's why when you come from this realm, since we've got the training, we can get up to speed because we're used to it. We're used to having a motion that's going to be heard tomorrow and knowing we got to spend the next 4 hours researching it. Even if it's up to midnight.
I think what you find is that judges who have been in the trenches understand a little bit better. And again, we have too many people out there who are able to run for judge only because they've been a lawyer for 5 years and they've got a license, and that's it. They don't need anything else. They have a name. They run on a name. In fact, I don't want to put Judge Jean on the spot, but I will be happy to call out the fact that her opponent is literally running on a name that she may have changed. I mean, I just read an article in the Miami Herald that addressed that very issue.
And she's not the first. Many of them do that.
It doesn't single her out for that, but there are plenty that do it.
It's not genuine. Let's be honest. It's not genuine because, if this is the way I see it, Judge, you don't speak here. You have nothing to say here. But me personally, Ed Martinez personally feels that it's inappropriate because if you didn't respect or honor that name enough to use it before you ran for judge, then you shouldn't be doing it now just to try and fool the public that doesn't know enough about the system into voting for you.
And another way to express that might be, you know, using the example of Elizabeth Warren and her, you know, alleged 1/1000th Indian heritage to declare herself a Native American. Look, you are who you are. And in this case, who is Judge Jean? You know, Judge Jean was born in Haiti. She lived there as a child. She came here as a young adult. She went to earned multiple degrees, 2 or 3 undergraduate degrees, and then went to St. Thomas and got a law degree. And then, you know, the rest is history. This is somebody who is true to who she is. But I want to share one other anecdote, and I hope this doesn't embarrass you, Your Honor, but I was on a Zoom cattle call calendar a couple of weeks ago in your courtroom, and it was a while before I got called. Most of the judges follow the same protocol, which is completely reasonable and understandable. They call the lawyers who are physically in the courtroom and the cases that are there first, and then they get onto their Zoom calendars. So while we're sitting and waiting, we get to kind of half pay attention or full, if we wish, to what's going on in the courtroom that we're not, you know, just not privy to. It's not our case. Anyhow, it was about 30 minutes or so that I was listening to you address other cases. And one of the things that you addressed was a pro se defendant in the courtroom. And I got to listen to how you spoke to that individual. And I was so overwhelmed and impressed with your patience and your respectful demeanor and just the way that you dealt with this guy. Because, I mean, I'm not going to name names like Ed doesn't, but over 31 years, I've practiced in front of many judges who are not as patient or polite.
What did I name? I haven't named anybody yet.
No, I'm saying like you. I'm not naming names, but
It's
we've
hard to hear
appeared in
because my
front of
speaker's
judges, you know,
Yeah.
what we would call judicial temperament. And so that's another thing that as a lawyer, we greatly respect. We like judges who treat us as adults, you know, and not chide us and not yell at us and not bark at us and not throw their weight around. We know you're the boss. We know, you know, but some judges just really need that ego stroke, right? I guess they have to know that they're on top and they have to let you know they're on top.
You know something, Mike? I think, again, going back to being a prosecutor, I learned rather quickly, and I think, Judge, correct me if I'm wrong, when you get to a certain level, at some point in the level, as you go up the ladder in the office, you start to really get a comprehension of just exactly how much power a prosecutor can wield. And what I learned, and the good ones, some don't, some of them never learned this, but Judge Jean seems to have learned, and her and I have never discussed this, but she seems to have learned that the more power you have, the more benevolent you need to be. And Judge Jean, you expressed that, Judge. I've seen that when you were in county and now in circuit. You are even more benevolent than you were as a prosecutor. You understand, I think that.
Because I serve. Serve, you know? It's a privilege to serve. It's an honor to serve, right? It's not for me. It's for the public. When I got elevated to circuit court, one of the quotes that the Daily Business Review got from me was, I pinch myself because I do. You know, I was a lawyer 14 years before I got appointed to the bench. I've been a judge for about 3.5 years. I guess I'm newer when it comes to the judiciary. I hope I never lose the feeling of what it is to want to pinch myself every day, to have the privilege and the honor to serve the community. And even though judges are human, I accept that the public does not deserve us having a bad day, right? Like, you know, a judge may get up on the wrong side of the bed. It's not fair to the person that appears in front of us for us having a bad day. I can accept if they never forgive us for that. I can, because we're supposed to be the best versions of ourselves every single day. Because someone could appear in front of me one time or 100 times, and they deserve my undivided attention every single time. Every single time. And
you do give it. You do give it. I've been in your courtroom several times, like Mike says, either on Zoom or in person. You do give it. You are fair. And you were like that also as a prosecutor. I got to be honest with you. You know, it's the same thing, right? Especially when you were division chief. You really can't afford to have a bad day and take it out on a defendant. And I know you took that very seriously.
It's not fair, right? And if someone does, they need to go apologize. They need to, because, you know, again, the public, those that we serve, they need us to be on our A game every single day. And listen, if we're not, and they want to forgive us for a bad day, great. But I can accept if they never, if they don't want to forgive us. I can
So,
accept
Judge,
that.
how do you do that? How do you do that as a judge? How do you come out every day and not have a bad day? Do you like meditate before you take the bench? Do you meditate driving into work? Because let's be honest, you're human.
You take some deep breaths before you actually walk in, right? And then I just remind myself that would I want to do this job on a very bad, tough day? And the answer is always yes. So whatever it is that I'm going through on the bench pales in comparison to having a very bad day. And even on that very bad day, I will remind myself, do I want to be here? And if the answer is yes, then I owe it to the public to perform to the best of my ability to continue to serve them.
Yeah, but that's a lot easier said than done, Judge.
It is. Listen, it's I'll tell you this. As judges, the conference of judges, we have to go to judicial college. They're aware that we do have bad days, and they're aware that they need to give us the support system to assist us. And there's little tricks, right? Some judges count to 10. Some judges take a break. Some judges need to have coffee on the bench. I mean, there's like little things. It's all about
some use vodka.
Well, I don't know if they use it. I think some need it.
maybe in the cup of coffee. I hope not. But
I think some of them need a Xanax, but that's a story for another time.
I mean,
some do that too, Ed.
A couple of my colleagues teach us yoga. A couple of our colleagues teach us breathing skills, and I can go on and on. Because some of us have had bad days, and some of us have learned how to identify those moments so that we can get through it.
Right. Well, I think it's important for people to register that, right? Because judges are people too. We use this a lot when it comes to police officers, right? As defense attorneys, it's important for us to remember that cops are people. They're subject to the same frailties as anybody else. We all have the same human condition. They have their job. They have what they're supposed to do. Sometimes they have a good day. Sometimes they have a bad day. Sometimes they make a good choice. Sometimes they make a bad choice. And so too are judges. You are people. So you are subject to that frailty. And it's really refreshing to know that you are attuned to it and that you keep it at the forefront of your mind, because it reduces and maybe not eliminates, but certainly reduces the possibility that it gets taken out on some poor John or Jane, Q citizen who's sitting in your courtroom. Right. Or worse yet, a lawyer like Ed or I.
And you do an excellent job. I've had a couple of clients with you. I had one client specifically that was going to get a very, very, very sweet deal. Very sweet deal. But he himself made a mistake. We won't get into the facts. And Judge Jean had to change, let's say. She had to modify the plea offer, and it now became a little harsher. But I will tell you this, Judge, in the hallway, he started crying and he said, I understand exactly why she did this. I did it to myself.
And he was a young man that probably needed a coming to Jesus moment, right?
Yeah, but you were fair to him. And he recognized because you gave him a fair shot until something came out that it was his mistake. So it's true what you say. I think people just want to make sure that they got a fair shot. That's all they want. And he did get a fair shot. I mean, it's not your fault that he himself, screwed himself over. That's not your fault. And you were still kind of fair to him.
And a lot of stuff, even when it's not a plea arrangement, you have jury issues. And so the judge is going to have, the judge isn't, yes, you're making rulings in terms of evidentiary matters and stuff like that. But at the end of the day, it's up to a jury to decide thumbs up, thumbs down, yay or nay. What are we going to do here? But how you interact with that jury is very critical.
Right.
Again, there are some judges who are just outright all business. There are others who are just outright nasty. And then there are others who really go out of their way to be just accommodating and thoughtful. And again, I found that you fall into that category of being conscientious of your audience, whether it's a lawyer, a pro se defendant, a jury, even your courtroom staff. The way that you interact with bailiffs and clerks and probation officers, it's really the standard for what we want our judges to do.
Thank you.
If they all did it your way, we'd have a much better bench.
Thank you.
That is true. Can I ask you a question? I'm just
Yeah.
curious, out of curiosity. Who was your judge when you were a division chief?
I had Stacy Glick.
Oh, oh,
I
And
had
that's
now
right.
she's
Stacey
your
Glick.
colleague.
And now she's a colleague. And then before that, I had Roberto Diaz and Peter Lopez.
So that you had three great judges.
Yeah. I mean,
Peter
I
Lopez.
tried.
So that I could see a little bit of Peter Lopez in you.
Listen,
I love Peter Lopez.
I tried and appeared in front of both men many times, many times. And I mean, look, they're humble, they're hardworking, they're knowledgeable.
Great
So,
judges.
whenever I talk about mentor judges, those are my top two.
Well,
Yeah,
I
but
would say
you
all
were in front
three.
of three very good judges.
I would say all three of those judges fall into the category, and you have clearly worked into that same niche of
Yeah.
of being just really wonderful jurists.
Yep.
Thank you. And Judge Glick, Stacy Glick, big heart, right? She can be tough. She could be tough, but she also wanted to help, especially young people,
Right.
So I appreciated her going on the limb many times when we were, handling
Yeah.
cases in her division.
I had a
she
case
was one
with
of those.
I had a case
Stacey
with
was
Judge
one of
Glick
those
early on in her
when she was.
career that you would be shocked if I told you how far she went out on a limb to help a young man. So
When she
you're
was in
absolutely
crim-
correct.
When she was in criminal, she was one of those judges who had a reputation for being tough, and she was tough. I mean, she wouldn't bat an eye to sentence somebody to life, but she had the ability to listen. Not the ability, she had the inclination to listen, and she was willing to go out on a limb and take a chance where it was reasonable for her to do so. I don't think she was going to put her neck on the chopping block for just anybody.
Yeah.
But
No,
if you could present her with
Right.
sufficient justification, with sufficient guarantees,
She just did-
protections, layers, she was willing to accommodate.
She just had a very good BS meter. That's the thing about Judge Glick.
Well, remember, you got to remember when it comes to Judge Glick, she grew up with Judge Glick,
Correct. And I was in front of her father.
and I practiced in front of Lenny many
Me
times.
too. She did not. He didn't have any. He didn't have any time for BS.
Yeah, it was
And
a little
she's
tougher.
even worse.
I do need to,
start.
I do need to mention two more judges. Orlando Prescott. I'm not supposed to age him, so I'm not. But I appeared in front of him as a young intern, and also very tough but fair, and serving the juvenile division for years, if not over a decade. And then one of the first mentor judges I had was Melvia Green. She served on the 3rd District Court of Appeal, first Black woman to ever serve in that position. Also a great role model. Also tough but fair jurist.
Well, I take back everything I said. You had too many good judges to train you. You got too many good ones. You did learn from them, though. You really did. You did take the good from them, and you're doing a wonderful job.
I want to make sure, because you're unfortunately, for whatever reason, the ticker information is not completely going across the screen. It's cutting off, and I want to make sure that everybody who's listening knows that the judicial election is this November.
It's actually August. It's actually August.
I'm sorry, I put it down as November 8th. What's the actual date?
August 23rd.
August 23rd. Okay, so I could have been wrong on the date, but I am definitely right on the group. This is Judicial Group 3, correct?
Right, I'm sorry.
And your vote number is 91. That's 9-1.
All they got to do is remember 91, right, Judge Gene? 91 is all they got to remember.
Ed and I very much encourage the public. We both endorse you. We both respect you. We both want to appear in front of you. We look forward to appearing in front of you, and we encourage the community to vote for you. They should do their diligence. They should do their diligence, because every citizen should know who you're voting for. Don't vote for somebody, I don't care what it's for, just because somebody else tells you to do it. Do it because you believe in your heart that it's the right thing to do.
Or like most people do, no judgment, but unless you don't really know what you're voting for. So a lot of people vote because it's the same race. A lot of Hispanics vote for Hispanic judges, which is why in Miami, some people change their names when they're voting for judge or any politician. Some blacks vote for blacks, women vote for women, men vote for men. I had a friend years ago who used to tell me he always voted for a woman, the prettiest woman on the thing, because I don't know. I guess he thought we were young. I guess he thought he could flirt with her. I don't know what the hell was going through his head, but that's what he did. It had nothing to do with the ability.
But these are irrational voting points.
These are judges that we can tell you, because we've been in front of them. These are the judges that you want. Judges that have the experience and the temperament which is what Judge Jean has, to be a very good judge. It's not just for Michael and I, it's for you out there, because you're the ones that have to pay. If I had a dime for every time one of my clients says, how could that judge be so stupid? I'd be like, well, you're the one who voted for him, or you didn't, and that's what got him there. Vote
Well,
for your judges.
I want to reiterate my list of adjectives again.
Yeah,
at
you
the
wrote
risk
them
of being
down.
overly flattering, but intelligent, experienced, patient, courteous, humble, compassionate, punctual, open-minded, courageous, fair, and exhibiting common sense. That is Judge Jean. Please vote number 91 this August. Keep Judge Jean. Elect
Give her
her.
the last 30
She was
seconds,
appointed-
45
She was,
seconds.
you got it. She was appointed by a governor to the county court. She was then bumped up by another governor to the circuit court. Both of those guys had it spot on, and they got it right. She's earned it. She deserves it. Please vote number 91 in August. Go ahead, Ed.
Judge, you close it out. Give you 30 seconds, 45 seconds, whatever you need.
Look, I think everybody knows that I serve wholeheartedly, diligently, and fairly. I was a lawyer 14 years before I became a judge. I've been a member of the Florida Bar 18 years. I like to think good litigators make good judges. Elections matter. Elections matter. You know, the voters deserve transparency. They also deserve a judiciary that will serve them with experience, be a qualified judiciary, and serves them with integrity. And I hope that I can earn the public support to stay on the bench. And again, thank you for letting me be here. My ballot number is 91.
That's all you got to
Thank you
remember,
so
guys.
much.
91 on August
23rd.
23rd. August 23rd.
Write it in your
live
calendar.
vote. All right, Judge, good to
82391.
see you.
Thank you all
Have
very
a good
much. We
day.
really appreciate your joining us, Judge, and we appreciate the folks watching episode number 44 of At Your Service with Haber and Martinez. We'll look forward to seeing you next week with episode 45. And we have another special guest, although not a judge, but we do have another guest to introduce you to, and we look forward to an exciting show. Thank you again, Your Honor. Thank you, Ed, and we'll see you all next